So I'd like to welcome everyone today to this, our first remote downtown CLE. We're grateful that we have the opportunity to present this to you because we didn't know how else to get the information out there, and we think it's really important. I'm Lori Nelson. I'm the Director of Alumni Relations at the University of Utah S.J. Quinney College of Law. And our two panelists today are very distinguished, very capable, very competent. First, we're going to hear from Professor George Contreras, and then we'll hear from Rand Bateman at Bateman IP, right, Rand?
Yep.
Not Bateman IP Law. Bateman IP. Okay. They're going to talk about the open COVID pledge regarding intellectual property during this time and the benefits, the pitfalls, and what your clients will have to look forward to in the future. So I'm going to turn it over to George first, and then he and Rand will have a conversation and discussion about these issues. We will try to leave 10 to 15 minutes at the end for questions. I encourage you to use the question and answer, the Q&A tab, to ask your questions. And if you see a question that you like, click on that and it will go up to the top, and we can make sure that the question that most people want answered will get answered. So with that, thank you all for participating. And George, I'll turn it over to you. You're on mute, George.
Yep.
There we go.
Thank you. Thanks a lot. I make that mistake every time, no matter how many Zoom calls or classes I've been on. So thanks. I appreciate it. It's really a privilege to be here and to talk with you all about a project that I never expected I would be working on a couple of months ago, but which has really turned into something that I think, and I hope you'll agree, is significant. So I'm going to share my screen, and hopefully you can all see some slides now. If you can't, just sort of call out. But as Lori mentioned, this is about the Open COVID Pledge. And the first thing that I should do is acknowledge that this is not my own work, or not the work of me alone. There's a large team of people around the world who have participated in creating this, this project, this pledge. We have both lawyers from the private sector, from academia, as well as engineers and scientists from a number of universities, all of whom contributed to putting this project together. And so, why did we do this? What was the impetus for it? Well, the impetus was news stories that started to appear shortly after the COVID-19 pandemic was declared about intellectual property and how, in a variety of cases and a variety of industries, the holders of intellectual property were potentially making it difficult for researchers to do research on COVID-19, for the manufacturers of parts for patented equipment like ventilators were being threatened or sued. And in all of these cases, ways that potentially existing intellectual property might make it harder or slower to develop and distribute cures and other equipment to remedy the COVID-19 situation. And by the way, I hear some background noise. I'm wondering if there's a way to just make sure everybody is muted who is on the call, and maybe our host can just do that, I think, with one button. Anyway, that was the impetus for it. These news stories began to emerge. And so what can you do about something like that? Well, there are ways that are well known for opening up intellectual property rights in one way or another. And they've been used historically in many different contexts. Compulsory licensing, for voluntary patent pools and clearinghouses, and then something called patent pledges. And I'll just run through these quite quickly. A compulsory licensing is a mechanism, it's authorized under international treaties, whereby access to intellectual property, usually patents on medications, is required by a government, right? This has happened with respect to HIV/AIDS medication and other some chemotherapy agents in the developing world over the past 20 or so years. This is not a new phenomenon. In the United States, we don't have that type of compulsory licensing mechanism, but we do have two similar mechanisms. One is a mechanism called margin rights under the 1980 Bayh-Dole Act, which allows a government agency that funded work that matured into intellectual property, patents specifically, to require the owner of those patents, usually university, to let others operate under them if the owner of the patents is not able to adequately meet the demand for whatever the product is. That this has never been exercised by a government agency, although there have been numerous petitions, particularly to the National Institutes of Health and National Cancer Institute, to march in particular cases. It is still a statutory option, though. The other US mechanism that's like compulsory licensing is called governmental use. It's called Section 1498. Section 1498 allows the federal government, not state, but the federal government to use any intellectual property that it wishes for governmental purposes upon payment of a royalty. This is used regularly, often in the defense industry. Other Department of Energy, Department of Defense, and so forth utilize this with some regularity. In the past, it's also been used with respect to drugs over 50 times, but again, has not really been talked about too much in the COVID context. Also, as Rand will talk about a little bit more at the end, in a number of countries, compulsory licensing measures have been discussed very recently in connection with COVID-19. These are just a few of the countries that have actually adopted legislation or regulation that would force the opening up of IP to address COVID-19. Okay, that's a fairly heavy-handed way to open up this intellectual property. Pools are a voluntary mechanism. Intellectual property pools have been used for a century. They aggregate IP rights that are held by multiple holders, going all the way back to oil and gas technology at the beginning of the 20th century, to much more familiar pools around all sorts of electronics standards. Music, ASCAP, BMI are copyright-related pools. And pools allow you to do a number of very helpful things. They eliminate blocking positions that any one IP holder may have to prevent the use of a device or a medication. They clear what are called IP thickets, which are situations when there are just many different owners that have IP, so it's difficult to aggregate all the rights that are necessary to use it. And it's an efficient solution because licensing can be done through one central pool, as opposed to going around and getting a license from all 100 of the holders of the relevant IP. That being said,
George, we're
yes.
we're just seeing the first screen.
You're seeing only the first screen?
Yeah, still on the cover sheet.
On the cover? Really?
Yep.
Oh, that's
what you're seeing, Lori?
Let's see what's happening.
There we go. Okay.
Oh, really? Is it better?
Yeah, now,
Yes.
now you're on the IPR pools.
That's really strange. Oh, I think I know. Okay. Yep. Zoom is our friend, but doesn't always behave. Okay. So let's move on. Pools, there have been a number of pools created in the past, but there's some complexities, some antitrust issues, as you can imagine, that need to be considered when you're collecting up assets by entities that were or are competitors. Generally, the antitrust agencies disfavor assembling pools that include technology substitutes, right? Things that can be substituted for one another, because if everything is thrown into the same pool, then it's less likely that those different product types will compete with each other. You have less incentive to improve your thing if it's all licensed anyway, along with the thing that everybody actually wants. And so when you create these pools, you generally have to do an antitrust and essentiality analysis of each IP right that's thrown in there to make sure that you only have complementary rights and not substitutes. And the reason there are dollar signs there is because that's an expensive activity. There have been a number of attempts to create pools in the biopharmaceutical sector around outbreaks and pandemics, starting with the SARS outbreak about 18 years ago, H5N1, these influenza epidemics, and even more recently with CRISPR-Cas9 gene editing technology. None of these pools really were successful. There are a number of reasons: the complexity of organizing them, the unwillingness of some entities to join. So as we look at the situation today, we have a number of pooling efforts that were not successful in the past. Now, hopefully that changed the slide. Yep, okay. So there's another mechanism that has been used in the past. They're called IP clearinghouses, and the somewhat inaccurately named Medicines Patent Pool is such a clearinghouse. It's organized by the World Health Organization and its sort of subsidiary organization, Unitaid. The goal of it was to get medications first for HIV, then also for tuberculosis, Hep C, into the developing world where people could not afford the medications at their retail price in the first world. The way the Medicines Patent Pool works is it accepts inbound licenses from pharmaceutical companies and others. There's a decent list of them today, and then grants sub-licenses to manufacturers of generic drugs in least developed countries or who will service least developed countries, right? And to date, 22 of these have been granted. So this is, to some degree, a success, something to be very positive about. Some of these licenses are even royalty bearing, where the generic manufacturer will pay a certain amount to the branded pharmaceutical or the patent holder that made the contribution. The Medicines Patent Pool requires money to operate. It is an agency that has a budget, these days closer to something like $8 million per year. But again, it does this sort of thing and it has been useful. So with that background, just a month ago, the government of Costa Rica proposed to the World Health Organization that a new patent pool be created around COVID-19. And that discussion is still ongoing now. All right, so what are patent pledges? This is something different than what we've just talked about. A patent pledge is a public commitment, a statement that a patent holder or another IP holder will make to limit the enforcement or utilization of their IP, generally without direct compensation. So these types of pledges have appeared in a variety of industries. About 20, 30 years ago, companies like IBM and Sun Microsystems said publicly that they wouldn't assert their patents against implementations of the Linux operating system for a variety of reasons, including to promote the adoption of Linux, where they all would have big business around selling servers and services. Interoperability standards are an area that I've worked in for a long time that involves pledges made by companies who are part of the standardization process, not to assert their patents or to charge only what are called fair, reasonable, and non-discriminatory royalties to those who wish to use their patents. In the green and clean tech space, we've seen these types of pledges, companies saying they won't assert patents against green or clean tech uses. And then finally, there have even been some in the biotech space. Okay, so what does that do for us today? Soon after the COVID-19 outbreak, a number of companies and institutions decided that they would unilaterally pledge that they would not assert patents against cures, vaccines, equipment used in the fight against COVID-19. Medtronic is one of the large ventilator manufacturers. IGI is a part of University of California, Berkeley. The CRISPR people that Jennifer Doudna leads I'll let Rand talk about some of these others because I think they tie into the compulsory licensing story. Coletra is an AbbVie HIV drug that people thought might have some benefit in the COVID-19 sphere. AbbVie made a pledge shortly after, like the day after Israel declared a compulsory license on that product. The Wellcome Trust was dealing more with scientific publications, got a large group of publishers to agree that their COVID-19 scientific literature would be taken out from behind their paywall. And Fortress is a patent assertion entity, acquired some patents from the now defunct Theranos company, the company that you may have read about or heard about, the book Bad Blood, in which basically defrauded the market by claiming it had a micro scale blood testing apparatus, even though the apparatus never worked. The patents did, and the patents are still being sold on the market and asserted by Fortress. Then after it received significant bad publicity for doing this during COVID-19, it pledged its own Theranos patents to the public. So anyway, there were some of these sporadic instances of pledges that arose in the marketplace, and the group of people who I mentioned early on got together and thought, well, you know, I wonder if it would be possible to do something more broadly based, right? Something that is simple, that people would be able to understand right away without committing to provide resources or technology transfer, something that's uniform, that once it's understood would be trusted, could be quickly adopted, would develop a community around it with some network effects so that, again, the more entities that make this pledge, the better it is for the community. Something that could be done in a self-executing way. You don't need signatures on a license. You don't want negotiation and administrative overhead. Something with limited scope, right? Only covering the pandemic, not a general gift of this intellectual property to the world, only a limited purpose contribution. But during that limited time, something that would be free. In the open software context, right, you hear about this is free speech, not free beer. Well, this is free speech and free beer because the goal is to have this IP available really to anyone who can make use of it for the limited purpose of fighting the pandemic, but at no charge. Okay, so these were the design principles that we developed, and with that, you know, you have to ask the question, why not just suggest that companies, entities, donate their IP to the public domain? And we thought that that was going a bit too far. There are defensive uses of IP. Many companies would not give away their IP if that left them unarmed against potential IP attacks on themselves. Also, we thought the limited duration and scope of such a pledge might induce or attract adopters because afterwards they have the potential to monetize whatever their intellectual property was, especially if it was used and taken up broadly during the pandemic. You know, that's sort of an advertisement for them for after the pandemic. And not only that, but there are certainly uses outside of COVID-19 that they could use to recoup some of their investment. And also, like in the open source code world, there are some restrictions that Rand will talk about in the license, and without any IP to back up those restrictions, it's difficult to enforce them. And so this is what we came up with. This is the pledge itself. We pledge to make our IP available free of charge for use in ending the pandemic and minimizing the impact of the disease. That is a very simple one-sentence statement, but behind that, there is more legal terminology. And I'll turn it over to Rand, I think, who can take us through some antecedents, what inspired the licenses themselves. And here we go. So this is what the license looks like. Rand, do you want to talk to this and some of the terms? And I can flip to the next slide too.
Yeah, I'll pick it up from here. Yeah, and anyone who's gone through the GNU license knows that it can be a challenge. It's very well lawyered. I think the most remarkable thing about the open COVID license, and compliments to George and the other attorneys who worked on it, it's remarkably simple. Something that attorneys are rarely accused of. The first one is the patent. The first version is the patent and copyright version. There was a 1.0, there's a 1.1, and we'll discuss the minor difference between them. But as George read, it's the opening clause is that we're pledging our IP to speed the development and dissemination of technologies needed for the disease. Can you scroll back down, George?
Yep.
Yeah, there we go. So first of all is the grant and the scope. The pledgers grant that anybody who wishes to accept a non-exclusive royalty worldwide free paid up license, but importantly without the right to sublicense, under the pledger's patents and copyrights, they have the right to use the licensed IP to make, have made, use, sell, or import any patented invention and reproduce, adapt, translate, etc., or otherwise exploit any copyrights for the purpose of diagnosing, preventing, containing, and treating COVID-19. As George mentioned earlier, this is important because a lot of the drugs and whatnot that have shown some promise in treating COVID-19 also have other uses in the medical field. And obviously, if you're a pharmaceutical company that has a very successful drug that's used to treat something else, you don't want to donate it to the public domain and suddenly give away a good revenue stream that's not related to the disease. So it's limited to the disease. Now, the second major continued is the time limitation. So the license starts effective December 1 of last year, and it lasts until 1 year after the health organization declares that the pandemic has ended. Now, the original version stopped there, but version 1.1 added in, but not in any event beyond January 1, 2023, unless otherwise extended by the pledger. So you're not giving a perpetual license. There is an end date where you can reevaluate if you want to keep the pledge going. And obviously, anyone looking at that's going to look at what the pandemic looks like at that point in time. You know, have we conquered this? Is it now just a minor inconvenience? If so, we probably don't need the pledge. If it's still a major health concern that's affecting the world, then we probably want to extend the pledge. But that gives companies a clear cutoff, kind of a sunset provision, so they can reevaluate it at that point in time. The next is the regulatory exclusivity. The pledger is agreeing not to assert any regulatory exclusivity against any other entity or individual to use with any individual or entity from doing so. Next, we've got the defensive suspension. The license and non-assertion covenant granted above can be automatically suspended, and the pledger is free to assert the license IP against the licensee if the licensee or any entity affiliated with the licensee threatens or initiates a suit or legal proceeding alleging infringement of any patent or other intellectual property right against the pledger or any entity affiliated with the pledger. So you can pull your patents out of the pledge if you need them to defend against somebody. And as George mentioned earlier, sometimes your best defense in an IP action is your own IP against the person who is asserting a claim against you. I can't see number 5. So the other thing that's good about the warranty or about the pledge is that there's no warranties involved. You're not guaranteeing anything, so you're not going to incur any liability if somebody uses your technology and mucks things up. You're not going to be on the hook for it. So it's a warranty-free way of letting people use your technology. Go to the next slide.
Yeah, let's see here. Oh, I think you've think you've gone through these. This is what you just did.
Yeah, so I mean, just in summary, the license rights, there's just a patent version, or there's a patent and copyright version. It doesn't address trade secrets or trademarks. So companies can keep those and protect them. And obviously from trademark point of view, you got to be careful about basically granting a naked license to use your trademarks. But there really shouldn't be a need for that. And it's only within the licensee's power to grant. The field is limited, again, to diagnosing, preventing, containing, and treating COVID-19. So you're not giving away all of your alternate uses of various medications. The term, relatively short period of time in this context. And then, you're waiving the right to use it. And I'll come back and I'll talk, George is going to talk a little bit more, and then I'll come back and talk about some issues with counseling your clients on whether the pledge is right for them. George?
Yeah, thanks. And so this last line here talks about customized licenses. So, we, the Open Pledge Coalition, we put together the 1.0 and 1.1 versions of the licenses that Rand mentioned, but some large companies, universities, and so forth, they, for various reasons, feel like they have to use their own paper, their own license, which have some unique terms. And so we allow that. They can do that. And then we will assess those against a list of compatibility criteria that we have. And we will then determine whether they're compatible or a little bit farther off their alternatives, even though a little bit different, still within the spirit and the scope of the pledge. And so that's all listed on the Open COVID Pledge website. One thing that I wanted to go through were just some of the omissions, right? Some of the things that are not in the license agreements that we put together, and why not? License agreements, those of you who write them and negotiate them know they're not short. There are a variety of things, warranties, indemnification, that are in most of these. They're fairly boilerplate, but technical as well. And we decided, just as a matter of judgment, that it would be faster and more efficient for entities to adopt the pledge, both as pledgeors and as users of this technology, without that stuff. So the warranties are not there because, as Rand mentioned, this is an as-is deal. An IP holder just commits their IP, but with no strings attached, right? You can't go back and sue them if the ventilator you built doesn't work or if somebody dies, right? I mean, that's a very important consideration. The IP holder should have no liability for that. Likewise, indemnification, indemnification could be available just as under the law, but contractually, there are just too many moving pieces to make it practical to have a sort of easily adoptable license. Same thing with choice of law. Everybody wants their own local choice of law, but honestly, we all know it's not really necessary, and so we leave it out. More importantly, grantbacks and share-alike clauses, right? These are clauses that appear many times in agreements that say, if you, the user, improves on my technology, you have to grant me back a license to use that improvement. Or in the more extreme version, which is found in a number of open source code licenses, the GPL style open source code licenses, you don't just have to give your improvement back to the licensor, you have to grant the world rights to that improvement on similar terms, on similar open source terms that you got the underlying IP on. And so that, while there are definitely benefits to it, it does make it a tougher buy for users. And there would be users who would not adopt this and not do this program if they had to grant back rights to all of their improvements. And again, in light of the pandemic, we thought it was more desirable to get as many adopters out there as possible, making stuff, moving stuff through the marketplace, and not restricting them, in leaving them unrestricted to the greatest extent possible. Same thing with downstream pricing constraints. You know, there are some pledges out there, particularly by universities, that will require the user of the licensed IP to commit that they will either give away their whatever they produce under the license for free, or distribute it only at cost, or at most on a cost plus basis. And there are reasons for that, right? You don't want to grant a free license to your IP and then have someone use it to price gouge by overcharging hospitals for the parts that they're making. That being said, you know, the adjudication of fair pricing is very difficult, very fraught. We did not want to get into it. And it's also a serious disincentive to commercial companies adopting the pledge of these licenses. So we decided we'll make this simple, not include any kind of pricing constraint, with the understanding that in fields outside of COVID-19 and for the time period after the pandemic, you know, anything goes. The parties can get together and negotiate a commercial license. So this is just a quick slide showing some of the adoption to date. There are more entities than are listed right up here, but this right now shows kind of the diversity of who has signed up. You know, we have a large portion of the high-tech industry, people like Intel and IBM and Microsoft, who have literally hundreds of thousands of patents, huge portfolios, you know, but in areas that are ancillary to sort of vaccines and drug development, but still quite important for the fight against COVID-19. You know, everything from tracing, contact tracing, to disease modeling, epidemiological tracking, prediction models that are all done in software through artificial intelligence. We have devices, you know, Amazon, which is basically, you know, feeding half of the country and, you know, supplying our closets and bathrooms with whatever stuff we need. You know, these are large scale enterprises that have lots of patents. We don't even know what all is there. I'll get to that in a minute. Then we have some small and medium entities who really are focused on single technologies. So, you know, a particular medical device or a part. National laboratories have picked out different portfolios to pledge. Sandia was the first to do this, but we were very happy to announce just a couple of days ago that NASA JPL has pledged a number of designs for ventilators that are available on its website. We've got a university, right? Not all the universities are going the way of the ones that I mentioned earlier. And then even this thing at the bottom, OVSI, is the Open Ventilator Systems Initiative, which is a UK-based group that is working to create a sort of an IP-free ventilator, an open source ventilator that can be deployed throughout the developing world. So it's a large variety of entities, and we see continuing interest every day. So it's really been a heartening thing. But one thing we wanted to do was avoid a trap that other efforts like this have fallen into. And I point to the Eco Patent Commons, which some of you may remember was announced to large publicity in 2008. It came out of the Davos conference. You know, a lot of big names were behind this. The big companies like IBM and Sony and Pitney Bowes would contribute a bunch of patents to making the world green, right? And this is a great thing, a great idea. But the problem was that after that initial publicity burst in 2008, 2009, pretty much nothing happened. And a number of years went by, the thing officially wound up in 2016. And why is that? You know, there was no ongoing stewardship. Nobody was continuing to mind the shop after the initial press releases was gone. And there was no linkage of the pledged intellectual property to users. It was just, you know, a list of patents on a website, which, you know, as most of us probably know, is not that easy to read. And especially if you're you know, you work at like the Red Cross or Doctors Without Borders, you're never going to figure out what you can do just by looking at a list of patent numbers. And there was also no tracking of the usage. You know, people could come to the website, potentially they could get some ideas and do something, but there was no reporting back. Who knew? And so for many of these reasons, this Eco Patent Commons was not successful in the long run. And this is a paper that I wrote with a couple of economists that more analytically assessed what happened there. So for the Open COVID Pledge, we do have a plan, which is number one, stewardship. So Creative Commons, which sort of created the world of simplistic template-based licensing of online content, is working with us and will be the permanent home of the Eco Patent Commons. They will translate this into, I don't know, 75 different languages, something like that. And they will, and we have also coordinated with similar efforts that are going on around the world. You may have seen an announcement 2 days ago about a Japanese initiative that looks very similar to the Open COVID Pledge. They have a large number of large industrial Japanese companies who have taken the same pledge, and we have some plans underway to cross-link our websites and so forth with them. And then most importantly, we have an effort underway to identify and promote the IP that has been pledged so it's most broadly useful around the world, right? Because you want to make a meaningful contribution to solving any technology bottlenecks that exist with respect to the COVID-19 response, and also more broadly develop a usable framework for the future. Once this pandemic is over and we can start to think about things like climate change again, having a platform like this in place hopefully will assist in that effort. Yeah, here we go. All right. And a final plug, if any of you out there are interested in this, we're not asking for money, but just your logo, would like to join, the Center for Law and Biomedical Sciences here at the law school, at Stanford and Cambridge and a bunch of other law firms and policy institutes who don't actually have IP of our own, but who are supporters of this, feel free to email opencovidpledge@gmail and let us know. And there's again no commitment involved in doing that. And so with that, I'll turn it back over to Rand to talk about some practical issues and questions. Oh, I think you're on mute.
Can you hear me now?
Yes.
Okay. So I want to thank George and everyone else he's working with. This is a great thing to pull together quickly and be able to get that many people involved. The challenge I think right now is that it's a lot more people that are on the periphery and not the people who are right in the center. And so as you talk with your clients are going to hear about this, and you're going to need to counsel them, is the pledge right for them? And first of all, there's the first issue of just the overall karma effect of doing things to help people in a time of crisis. Generally what goes around comes around, but also there's the public relations value of the pledge. All of us as patent attorneys are familiar with the last 6 years of turmoil that have been caused in the patent prosecution sphere because some people in society and some people on the Supreme Court thought the patents were getting too strong. And so they decided to fix it the best way they knew how, which was basically to muck everything up and leave us with tests that nobody knows how they apply. It's like we're applying the pornography test to patentability now. I'll know it when I see it. And so one of the things that IP owners need to be aware of is, are we putting ourselves in a position where we're convincing the government you don't need to intervene? And one of the important things for a lot of companies is going to be, what would be the financial impact on my company of joining the pledge? If your company has a drug, for example, that has other uses and is making a lot of money off those, it may be able to pledge use of that drug specifically for COVID-19 and not have a major impact. But if your company is spending tens or hundreds of millions of dollars trying to develop a new vaccine for COVID or something related to that, you might not be able to do the pledge. You need to be able to monetize that to get back your investment. And if you've said, yeah, anybody can use our technology as soon as we've developed the vaccine, that may have severe financial implications for your company. So there could be something like that. The other thing somebody could do is look at something where they would pledge, maybe, allow, as the some of the other patent pools that who handles is, we're going to license this for nothing or next to nothing for use in the third world. So they can have access to the drugs. The U.S. insurance companies can pay a reasonable price for it, but we'll license some generic makers to make it, and then they can supply the third world because they're being affected by this too. But that's something really important with counseling your clients, is what's the impact going to be or likely to be of joining the pledge. And could you skip down the next one, George? The other thing is, anytime the government decides to intervene in the system, it makes most IP owners a little bit nervous. Israel has already, as George mentioned earlier, done a compulsory license from AbbVie's drug that George had up on the screen earlier. Canada, Germany, and France have all passed laws recently that will make it easier for their governments to declare compulsory licenses on patented inventions. Canada is probably the more conservative of the three. Germany's broader, and then France is the broadest of those three. And then there's countries that are discussing compulsory licensing. Chile, Ecuador, and Australia, various politicians in those countries have all passed resolutions asking the government to look at it. In the US, there's some congressional Congress members who are looking at that. And then you have Section 1498 under US law, where the government can use it anyway. But I think most IP owners realize that anytime you get the government granting compulsory licenses or taking IP, it just gets easier for them to do the next time. And so one of the things that companies ought to consider in the pledge is, if we do the pledge, if we get through the pandemic, will that help convince the government that we can play nice and solve a serious problem without them needing to get involved and deprecate people's intellectual property rights? Leave that to the companies, and the majority of companies will work together and come up with a solution that will help us move forward. So those are some considerations if any of your clients are considering taking the pledge. Those are some things you should discuss with them. And is this right for them? For some companies, it's a great thing to do. I think it will give them a lot of good publicity. But for other companies, I don't think financially it would make any sense, because they may be giving away technology they spent years and years, and they're just at the cusp, and then all of a sudden they're almost dedicating it to the public. So it'll have to be on a case-by-case basis.
Okay, I think that's it. So with that, we turn it back over to Lori to monitor the Q&A.
Thank you. So far I have one question. There's time for more questions, and we want to make sure we get the full hour of CLE in, so please don't hesitate to ask questions. The first question we have, and this goes to both Rand and George: what precedents or case law can you point to that demonstrates the pledge is enforceable?
Yeah, so I can take that first stab. So there are a number of theories, right? There's the pledge, and then there's the license that goes behind it. Our position is that they're both enforceable. But the license is an easy case, right? There certainly are cases around open source code licenses, right? You can have unilateral public licenses granted by an IP holder to basically anyone who wants to accept it. So if you want a Federal Circuit case, take Jacobson versus Katzer from, I think, 2008, in which there's a open source code license of all things on open source code software to control model trains, right? Which you wouldn't have thought was a huge industry, but apparently was enough to motivate the parties, at least to appeal up to the Federal Circuit. And yet license clearly enforceable. And there are numerous cases around enforcement of open source code licenses outside of the US as well, in Europe, in the Netherlands, in France, where they're upheld. Basically the same as any click wrap, contract of adhesion that you have with your AT&T phone service and so forth. The pledge itself, it's broader, it's more general, right? It may lack some of the specificity of a signed contract, but there is, I think, good theory behind the proposition that a public statement on which others rely is going to be enforceable under a promissory estoppel theory. I've got like a 80-page paper about that, which you're welcome to look up. But we do see this in the standards area. Companies that make FRAND commitments, or commitments to license on fair, reasonable, and non-discriminatory terms, even though none of that is defined, the commitment is one sentence long. Those have definitely been held to be enforceable in big litigation. TCL versus Ericsson, Microsoft versus Motorola, the Innovatio cases. There are a number of cases in which they've been enforceable.
Thanks.
I don't know if you want to add anything, or if Lori wants
Rand?
to go on.
George is the expert on that. I'm not gonna.
So our second question is, for a drug, how would you police whether the drug is sold for COVID versus sold for other purposes?
What do you want to take?
Yeah, I mean, I think I think you would have to, talk with whoever's using it and come up with some way of dealing with that. I mean, for example, if you take hydroxychloroquine, that has huge numbers of other applications, for malaria drugs, for lupus, for some other autoimmune diseases. And so you would want some control that, okay, we make sure that we're prescribing this, although hydroxychloroquine is generic, so it doesn't matter. But if you had a drug like that, you'd want to have some restrictions maybe in how it was dispensed. Maybe somebody had to have a COVID prescription specifically and it was sent to them, or I think you could work out with the licensee some reasonable way so that you're not contaminating your chain of distribution with the alternate drug. You can even have it the drug process so it looks different, so people know this is the COVID version of the drug and not the other version.
That's true.
So
the pill could say C19 on it or something, and if you're taking it for something else, you better watch out. But I was throwing that. So this is a huge problem. The COVID-19 aside, this is a huge problem for pharmaceutical manufacturers today with off-label use. You have a drug for X indication. There's nothing that stops doctors from prescribing it for Y indication, pharmacists for distributing it for Y indication, and people take it. And sometimes the off-label uses are more lucrative than the original approved use. And it's a problem much beyond the COVID-19 issue.
Well, and that goes to a related question, and that is, what about diagnostics that can be used to diagnose COVID-19 or other things such as flu? So can you license for COVID only? And if so, how would that work?
I mean, I would just, off the top of my head, jump in and say COVID-19, this one actually is easier than the off-label question, right? Because unlike for the flu and, for, TB or whatever other disease you might be diagnosed for, there are going to be testing stations, right? There are specific COVID testing stations where people are going in specifically to get tested for this disease. It's not just like your regular, you send your blood sample off to the lab and they blood sugar level and cholesterol and 20 other things, and you don't really know what it's going to be. Here, there's going to be specific accounting from those testing stations. And it seems like, at least with the amount of money that this state is pouring into it, those testing stations will do a lot of the COVID testing.
Okay, so some technical questions. The first one, does pledgeor include affiliates? The pledge uses the phrase pledgeor or any entity affiliated with the pledgeor, which suggests pledgeor does not include affiliates.
Yeah, well, I mean, there's an entity making pledge, just like typically in a contract, there's one entity signing the contract. If it's the top level entity in sort of the corporate pyramid, then, it will bind its subsidiaries and divisions and so forth. But the pledgeor is the entity. Typically, we'd like it to be the entity that holds the IP. That would be the most legally secure way. But, we certainly don't purport to look into these enormous companies. Many companies, they'll hold IP in an offshore, Dutch Antilles company or something for tax purposes. We have no aspiration to go there. I would say, though, that if, a large company does make this pledge and then, 6 months later tries to bring a lawsuit because under patents held by its Dutch Antilles holding company, I think that would not be viewed favorably by the courts.
Okay. Is the defensive suspension effective upon triggering or ab initio? In other words, does a suspendee only face liability post-triggering or also for pre-triggering behavior?
Yeah. Randy, feel free to jump in on any of these.
Go ahead.
Yeah, I mean, believe it or not, we actually thought about that. The suspension, it's on a going forward basis, but that's not to say, somebody couldn't draft a custom license to make it ab initio. The defensive suspension works primarily as a deterrent mechanism. Whether it's going forward or whether there's a look back, it's primarily a deterrent, except in one case that I've actually seen come up, which is accidental threats. Some of these large companies, divisions don't talk to each other, so the company basically, out of the Office of General Counsel, has made this pledge for all the reasons that Rand talked about. That doesn't mean that, some in-house counsel in the, some subsidiary off in a different state might not send a demand letter to somebody without realizing what they're doing. And that kind of threat, we didn't want to blow up the entire thing, but we wanted them to be able to take it back. The ab initio versus going forward question is really just a question of severity. I think it's written on a going forward basis, but I think it would be consistent for someone to draft a custom version that acted as of the initiation of the license.
Okay. And also, how would one go about withdrawing the pledge in the face of, for example, acquisition of the patent owner if the acquirer didn't like the pledge?
I think our position is that this is an irrevocable pledge. When you acquire a company that's made the pledge, that's baggage that you bring along. You can't revoke it. I mean, revoking it would defeat the entire purpose of the thing.
I'd have a little different view. I could potentially revoke it, but it would be revoked going forward. So you couldn't revoke it and then say, all right, now I'm suing you for what you did. But I think if somebody came out and very publicly said, yes, we were part of the pledge, we're withdrawing from that, because then people are no longer, after that point, they shouldn't be detrimentally relying on it. You may have a situation where someone says, well, we've invested $10 million based on your pledge. And a court may find some equitable rights there, that entity that had invested a lot may be able to use the rights for some period of time. So there's some equitable remedies that could come in, but I think you could get out of somebody who adopted after that point of view decided to start using it, I think you could get rid of that argument by doing the a very public.
Yeah, maybe. It's certainly possible. You know, that would be an interesting case to try. I mean, another thing you could do is cabin the pledge to the acquired subsidiary, right? And, you know, there's always this worry about whether some commitment made by an acquired subsidiary is going to infect the acquirer and the new parent company. And, you know, you wouldn't necessarily want that to happen. So, you know, you could, I think, pretty comfortably make an argument that the pledge applies to that sub, and it's like 2 patents, but not to my 50,000 patents, you know, now that I'm acquiring them. So another.
So I've got 2 more questions and 3 minutes, guys. So would the pledge burden an asset sold by the pledgeor to an entity that itself has not issued the pledge?
So that's a similar question.
Yeah.
You know, does the pledge, does it have a viral effect, like within the organization? You know, legally, obviously it depends on the structure of the acquisition, but I would say, sort of as a rule of thumb, it should only bind the entity that made it. So if that entity is maintained as a separate subsidiary after a merger, then it would be isolated in the subsidiary. But if it merged into a new parent corporation that assumed all of its assets and liabilities, I think you've got a risk that it would infect the entire thing. But, you know, this is a question that applies to all licensing agreements. This is not unique to this pledge. This applies to everything. And that's, you know, sort of a due diligence matter that the acquirer will dig into.
Okay. And last, would the pledge cover indirect infringement?
I think so.
Yeah, right.
Correct. I think it would cover indirect. Right? You're talking about induced infringement or joint infringement.
Yeah, I agree.
If you're waiving direct, you're not waiving indirect.
Well, but there's got to be a direct infringement for any indirect infringement.
Right.
And so if you're licensed for the direct infringement, then indirect infringement would be kind of hard to you know, to find. But I would, again, it seems kind of sneaky, right, to say I'm granting this license to the world for, and then, but I'm going to sue you for inducing. Seems a little underhanded.
Okay, so there are still some questions that haven't been able to be answered. If those of you that have questions pending want them to be answered, please email me at lori.nelson@law.utah.edu, lori.nelson, and I will get those to George and Rand and have them respond to those questions. Thank you all for coming. Thank you to George and Rand for participating. This is fascinating stuff, and the questions, I don't know anything about patent law, but it's like, well, does this apply everywhere? Is this worldwide? Is this just the United States? How does it work? Where are the treaties? So I think this is fascinating, and I really, really appreciate the thought-provoking presentation you gave us. So we can't all clap, but thank you, everyone, and thank you for attending. And again, thanks to Rand and George.
Thank you.
Bye-bye, everyone.